Hello, hello, happy weekend. Hello, hello. Yay! Yay! I see lots of people I like in the chat. I like all of you, but some of my favorites are here. What's up? Let's say hello. Let's say hello. Happy Saturday. I see beautiful Augie. I see Sarah. Hello, Sarah girl. I see Chicken Nugget. Chicken Nugget, I'm going to come back to your comment. I see Pantera. Happy weekend. It's good to see you guys. We're back with Sidney Powell. Yes. It's the last one until we find out whether she's going to have another trial or she's going to take a plea deal. So for those of you, welcome everyone who's here and watching. If a little rundown on Sidney Powell, she ended up unaliving her mother in their home. She has been diagnosed with schizophrenia, which they say plays a role into the crime. And so as of December 26th, her appeal has been approved. Her conviction is being overturned due to a rebuttal issue with one of the medical professionals. And so we might see a new trial, or she'll probably take a plea deal. So today we're going to watch the rebuttal from the state, and then we're going to watch the verdict, which I don't have the full video. It's only going to be like 7 minutes of it. And then we have the full sentencing, which isn't very long, but we're going to get through it. We're going to finish it. And then I have another live scheduled after this Karen Read case. If you follow, you know. And then I might be doing one later tonight. So thank you for being here. And I hope you guys enjoy this. I will still continue to be talking about the Sidney Powell case, but for now, this is the end of the trial. So I saw Chicken Nuggets comment said, "Hey, Melly in chat. Last night's YouTube Streets was wild. Good to see you on panel." Yes, I was on YouTube Streets panel last night. So go and check it out if you follow the Wade Wilson case and stuff. I don't really, but I do. Well, I do, but I'm not super into it like a lot of other people. But yes, I was on panel. I love being on panel. Hey, Kate, did I miss you? Good to see you, Liv. Okay, so let's get started. We're going to listen to the rebuttal argument for Sidney Powell. And then the verdict, and then the closing. They're all fairly short, so it shouldn't take too long, but I appreciate you guys for being here on a Saturday. It's the weekend. I have a couple lives planned, so I hope you guys can make it to those. I think the Karen Read one will be fun since I haven't covered that here before, although I do follow that case very well, and I followed the trial as well. So let's get started on Sidney Powell.
Jury selection in this case that was about 6 months ago. I appreciate you listening to all of the evidence. One of the things why I mentioned jury selection is there are some questions.
This is the rebuttal from the state.
During that process.
Good to see you.
And I always find it challenging when I'm talking to jurors in jury selection and trying to explain certain concepts that it's very difficult to do in a vacuum. And you heard a little bit about the facts of this case, but certainly not everything you've heard now. Now, one of the things that I asked each and every one of you, as difficult as it may be, could putting aside feelings of sympathy or empathy.
Oh yeah, it's Saturday. We always get freaky on Saturday.
Are you able to do that? Now, when you're sitting in that jury selection room and you don't know anything about the case versus now I think you understand why I asked those questions. Because this is going to be incredibly difficult to put aside those considerations and to follow the facts and the law. I can't imagine, it's difficult for anybody, right? Sitting through this case, you are all human beings, and I'm sure any human being who sees this case can't help but feel the strongest sympathy and empathy for this family. And as Attorney 𝗟𝗡 said in his opening statement, it's time to end this nightmare.
So clearly the state believes that she was not schizophrenic. If you saw any of the previous parts, this is part 7. So part 1 has all the body cam footage, all the information. Go back and watch. There was a stage scene. She was lying about being expelled from college for months. So the state believes that doesn't prove that she did not know right from wrong and that she is not guilty. She's not insane, not guilty by reason of insanity. And so she and her defense claims that she had been going through a psychotic episode or schizophrenic episode for months prior to the crime. So this is a rebuttal of the state.
Now, ladies and gentlemen, your sworn oath.
Yeah, tell me how you get her butt over here.
This is why it's tough.
I'm still going to email you back, Didi. I just have
it's not to feel some sympathy for this family,
so
which you may do, and that's fine. But each and every one of you, as you go through this deliberative process, is going to have to ask yourselves, is my thinking based on my emotion about this case or the facts and the law? Is my thinking about how I feel about this case based on all of Ms. Powell's family support, or is it on the facts and the law? Each one of you is going to have to do that. And you are duty-bound to follow the facts and the law without sympathy or prejudice. And ladies and gentlemen, one of the reasons I say this is not because I just want to win a case or I'm looking for a conviction or a certain result, but putting that aside, that's the funny thing about the law. It's supposed to protect all of us equally. And the judge is going to read you these jury instructions.
I feel bad too.
In a minute. And there is no exception in the jury instructions for, well, if you feel sympathetic towards somebody, your verdict, that can influence your verdict. Or if you feel that Ms. Powell has this bunch of family support behind her, well, then I can make an exception. That is nowhere in these instructions.
Thank you for being
here. I'm not asking you to be robots.
Appreciate you.
You are human, and you're going to go through emotions in that jury room. But ultimately, at the end of the day, to use the psychological parlance, you can't let those considerations inform your verdict. Ladies and gentlemen, so let's talk about the experts. And I also asked you in the beginning of this case, when we were doing jury selection, why don't we just pick our experts, have them testify, and call it a day? I hope now you at least understand why that is. Because so many of the facts of this case, in those 3 days that we presented our evidence, inform you of your decisions and deliberations you're going to have to make in this case. You can't just look at this case in a vacuum and say, well, the defense experts say this, and the prosecution expert says that, let's just pick who's right. Because ultimately, and this is the law, that whether somebody is insane at the time of the crime is a factual issue to be decided by the jury.
Chicken nugget.
That's why we don't just have experts and have a judge decide. It is up to you all to make that determination. And while we're talking about the experts, let's first talk about the state's expert, Dr. 𝗟𝗶𝗸𝗲.
Oh, my love.
Ladies and gentlemen, I submit to you one of the reasons why the defense is attacking her so hard is because it's obvious. If it's not obvious to you by now, it should be. She is the only expert you heard from that actually looked at the evidence. Objection.
I'm going to pardon me?
I'm sorry, argument.
He's like, I'm arguing.
I'm going to overrule.
She's the only expert that looked at the evidence. And ladies and gentlemen, the defense is so desperate to make you believe or to convince you that all the tests that all their experts did, all those acronyms of all those tests are the conclusive answer to this case, that they did all these psychological testings. But ladies and gentlemen, you don't need Dr. 𝗟𝗶𝗸𝗲 to tell you that a test you give somebody 2 or 3 years later is not going to give you the answer. You don't need a doctor to tell you that. Your common sense tells you that. And just because you're sitting in that jury box doesn't mean you put aside your common sense.
Whoa, chill out, yo.
Those tests, while they may measure what Sydney is going through at the time they are administered, and let me just talk about that for a second. Ladies and gentlemen, I don't doubt.
But he is right.
That
I do agree.
Ms. Powell may have some major mental health issues going on in these last 3 years. That's why I asked Dr. Reardon that. Would losing your mother and your best friend, in and of itself, cause psychological issues? Of course. On top of that, that you did it, yes. On top of that, now you're facing murder charges. So I don't doubt that some of these doctors are giving all these tests to Ms. Powell, that they are finding, hey, she needs some help.
Okay, so from previous parts of this case that we've covered, we saw that there was no signs of mental health issues, right? From her family and her parents. So do you believe that? Can you agree with that? That there was no signs in her childhood, no signs at all. And then all of a sudden in the fall or winter of 2019, she starts experiencing these symptoms, goes to school, lies about being expelled. Her mom finds out, her mom calls her on it, and she stabs her mom 30 times in the neck and in the throat. And now it's revealed that she's schizophrenic. It's a lot to handle. It's a lot to handle and process.
But those tests do not tell you anything about
we should have tested as
mental
soon as they were able not use
at
it.
the
Right.
time of the crime. No matter how desperately the defense wants you to believe that, it's just not the case.
Right. Thank you, Pantera.
Attorney
No, she
Marsick
didn't have
said,
anything in
is this
her
her
system. She
plan
wasn't drunk or high
to
or
lie to these doctors, to fake all these illnesses, the Meryl Streep and such as he's going on? Well, what does the evidence show? The evidence shows that 4 days after she's in the hospital after the murder, she says, I don't want to speak to any family. I just want to speak to my lawyer. So yes, I submit to you that during these 3.5 years, yes.
I have 3 shows today.
This NGRI is part of her legal strategy.
I'm glad you're here. Good to see you, Kella.
And Dr. Attorney Marsick's like, well, Dr. Smartnick, did she just pull the wool over his eyes? This is why you need the details matter. Because Dr. Smartnick says,
hey, Corso,
if you look at his report, I meet with her about every 3 months. And some of the other experts will say, I only met her via Zoom. Because remember, some of these evaluations took place during COVID. Now, that's not their fault. But to say, well, she pulled the wool over these experts' eyes, these experts didn't spend every single day with her or even meet with her every week. Please take that into consideration when you're making your determination.
And remember, the dad found out that she was home and he rushed home. I always think that's a sign because, like, if you're that worried about her reaction, then you know something's going on. Dee Dee says the way those parents enabled her not to surprise that they didn't pick up on the mental issues, right? But it is common. I think she probably had hidden mental health issues that were triggered by getting kicked out of school. Who's getting detention today? Yeah, I agree, Chicken Nugget. I do agree. I do think the academic pressure plays a factor.
A few things on the facts. Mr. McLeese went over them in detail. But ladies and gentlemen, the state is not saying
this is the rebuttal, by the way.
Some sort of elaborate, well-planned plan.
Sentencing next.
It wasn't. As Dr. 𝗟𝗶𝗸𝗲 said, Sydney just kind of planned step to step to step. She didn't know what she was going to do next, but I guarantee you she was doing everything she could to get to that March 4th spring break, because then she'd have a reason to be home for a week, and then the next step would be something else. But this wasn't an elaborate, well-planned plan. That's why it was done so sloppily. And there is no evidence that, Mr. McLaughlin wants to use these 26 minutes because she knew the police were coming and she had 26 minutes. Why? Think about, why was Brenda in the bedroom? Something that we haven't really talked about. Why did this happen in her bedroom? If, as you would, the defense would have you believe, actually, as Sydney would have you believe, she and Brenda were having this heart-to-heart, and everything was going to be fine, and I'm going to call Mount Union. And even the message said, Sydney's sitting right next to her. Yet, at the time of the murder, she is back in a bedroom.
So then it was a lie, right? They weren't on the couch.
Is it possible that at some point, Brenda said, you know what, Sydney, enough of what you're saying. I need to go back in the bedroom. I need to talk to them alone, and then I'll come back out and talk to you. Because all the evidence points to is that this was a surprise attack. Sydney wasn't sitting on the bed next to Brenda when she was attacked.
I very much agree with that.
You have to think about what Gaffney and Frazier said they heard. But think about what they did.
I didn't think of that until now.
They didn't hear, Sydney, what are you doing? Sydney, put that down. Why do you have a frying pan in here?
In the bedroom.
Not one word other than, thanks for calling me back, and thud.
We saw the crime scene photos on the last live.
And the frying pan
in the bedroom
makes sense in terms of Sydney's lack of planning. Because that is a small house. Maybe when Brenda goes down the hallway to the bedroom, you stay here, I'm calling Mount Union. And she grabs the first thing she can find, the pan. But never forget, during your deliberations, at some point during this attack, Sydney stopped attacking with the pan, presumably went to the kitchen to get a knife, because that's where they are, unless, I don't think we heard any evidence that Brenda would keep a steak knife in her bedroom. She had to switch weapons and keep attacking her. And when you're figuring out whether the murder was purposeful or felony murder, like Mr. McAleese was saying, please think about those injuries. Because I could see the frying pan just in a rage or snapped or whatever it was, but that knife just in the neck multiple times, that's purposeful. That is trying to end someone.
30 stab wounds, overkill. We talked about it in every single part of this case. That's overkill. I'm getting intentional vibes.
That's the defense. I'm going to go back to this. That the defense keeps saying she had 26 minutes. She had 26 minutes. She had all this time. Why didn't she flee? That's assuming, because I said, why was Brenda back in her bedroom? If she said, Sydney, I need a minute, I'm talking to them. She's isolating herself in the bedroom because she wants privacy. They're not going to be on speakerphone. She's going to have the phone up to her ear, and then when the attack happens, the phone drops. So when Ms. Gaffney saying, I'm calling the police, you have a phone that's probably not on speaker, that's on the floor. Do you really think she's going to hear that?
Not on the weekend.
I submit to you, at that time, Sydney had no idea the police were on their way. The evidence shows that the only time she knew the police were on their way was when her dad told her. And that's when she started scrambling. That's when she made these conscious decisions to lie about being her mom, to go outside, to actually think about, not just do I need to break this back window, I need to actually go outside, break it from the outside. You saw the splatter. Brenda's blood's already on her arm as she's breaking that window from the outside. She is thinking in the moment. And there's no other conclusion to reach other than that.
Oh no.
Ladies and gentlemen,
she doesn't look up at all.
Very clear, and you'll have all the reports. You've heard all the testimony. That much of what the defense experts and even the initial hospital evaluations base their evaluations and their opinions on are the word of Sidney Powell. And please, in your deliberations, remember that this is a woman who is able to lie by deliberate lie or a lie of omission to those closest to her for months.
I'm going to pull up the PowerPoint.
Over and over and over again. Is it really that much of a stretch to think she had the capacity to feign symptoms, exaggerate symptoms, or downright lie?
Can we smoke?
Of course.
We can do whatever we want to do in detention, baby. We do not judge here. And I'm wild. Y'all already know.
The defense makes so much of the motive, and the state can't tell you why. Ladies and gentlemen, again, this is why I asked it in all the way back in jury selection. Not every brutal crime that doesn't seem to make sense right away is insanity. That's why I asked in jury selection. So every time a shooter goes into an elementary school and shoots up a classroom full of kids, god awful as that is, must always be insane? Of course not. I think we heard some testimony on that. I think even Dr. Reardon said that wasn't the case.
Sharing is
You
caring.
have to ask yourselves, if Sidney was on the verge of this psychotic break, not in control of her actions, completely unaware of what she was doing, she had 45 minutes with Brenda. Why not kill her in those first 45 minutes? She only attacks her when she's on the phone with Mount Union, right when her secrets are about to be discovered.
I didn't think of that.
And I submit to you, that's why this happened. Was it some argument between the two of them? I don't think even in that moment she wanted her mother dead. She just wanted to prevent her secret from coming out, which she had tried for months. Think about the will it takes to keep this a secret for months. She had done that, and she's about to be discovered.
A whole semester.
Attorney Larson used the phrase rational a few times. Ladies and gentlemen, it is not rational to kill your mom to prevent from being found out. But it's not insane. It's not something you or I would do. And actually, I believe Dr. Swales or Timmy actually used the word irrational in their report. And that simply means not logical. But that is not legal insanity. She was trying to stop from being discovered at any cost.
Oof.
She panicked, she overreacted, and she took it too far, and she covered it up. That is what happened here.
Oh. Was it the grades? Was it the school? Or was there something else? We heard from the friends in the police interrogation. I think it was part 1, maybe part 2. I still have to make the playlist, but go back and watch. Her friends say that she was hiding a lot. She had a boyfriend. She was like drinking and partying, and her family didn't know that, or they say they didn't know that. So I think there was definitely stuff that was hidden. I think keeping the secret made her worse. Thinking about it for months, it's enough to make someone go crazy. Yes. No lie is ever better than the truth. Growing up, my dad always told me that. She lies easily. I agree.
Please look through those reports And I really
It's not
want those
insane,
expert reports.
just a bit extreme.
I want you to focus on how much time the defense experts actually chose to talk about Sydney's actions at the time of the crime. The getting on the phone, pretending she was Brenda, the breaking of the window, the making up of the story. It's almost zero. The only time Dr. Timmy mentions it is when he's criticizing Dr. 𝗟𝗏𝗏𝗏. But there's no section in any of the reports that say, all right, well, let's talk about her actions at the time. And I just want to, just as an aside, I think it's an incredibly unfair criticism to attack Dr. 𝗟𝗏𝗏𝗏 over this being like the first time she's testified and attacking her credentials.
Not the shade.
First of all, what did I ask Dr. Reardon, who's been around forever, how many reports has he written? Well over 2,000. Sir, how many times have you actually testified in court? 50 to 100 in a 50-year career. That shows you that these cases like this just don't go to trial a whole lot. That doesn't mean somebody's not qualified to give an opinion. It's like asking a brain surgeon who's done 1,000 brain surgeries, but has never been sued and never come to court. Well, you've never testified about brain surgery, so I guess you're not qualified. And I guarantee you, Dr. 𝐁𝐮𝐲, Dr. Timmy, and Dr. Reardon all had a first time too. So to say it's because that first time she's testifying, that's incredibly unfair.
She's actually lucky she got an appeal. She better plead out. I think it'll happen.
Please, again, ask yourselves, why don't they focus on the facts as they happen? Why didn't they want those phone records?
Do not. Don't come for me.
That's objective fact.
It's coming for me.
I mean, you could look at it yourself. You could look at Dr. 𝗟𝗏𝗏𝗏's report. I mean, she's reporting what she sees on the phone. This isn't some lost week where Sydney didn't know what she was doing. She's able to check into motels, and she's actually able to search how to convert coins to cash. That's a rational, goal-oriented decision-making. This isn't some lost week where she's in a psychotic break. All three experts and a number of professionals initially, you know what, and I don't fault those hospital doctors, by the way, because they're taking what's in front of them. If any one of us were to kill somebody without an explanation, go to the hospital and say, I'm feeling suicidal and I'm hearing voices, what do you think the hospital's going to do?
Good to see you, Pink Pixie.
They're going to do what they did here. But that's not NGRI. That's not insanity.
Lily, your ass better stay.
Those
Kidding, my Lily.
Experts and treating doctors, they believed Sydney. They took her at her word. They trusted her that she was telling the truth. The question is, do you? After all you've heard about her lying and how she...
Oh, sorry.
Experts and treating doctors, they believed Sydney. They took her at her word. They trusted her that she was telling the truth. The question is, do you?
What do you?
After all you've heard about her lying and how she's able to tell specific lies, even in the moment, to get out of a jam or to deflect. I think even her mom said it, texted her one time, well, why aren't you in class? Why aren't you in class? Well, the professor, they're on vacation. She comes up with like this elaborate lie. That is the person we're dealing with. That's what she's capable of. Please also think about what my colleague mentioned about the difference in our murder charges. One is purpose murder, and the other is felony murder. And to elaborate on that, as Mr. McLaughlin says, even if you don't intend for somebody to die, if you cause an injury or do an action deliberately that results in their death, you are responsible. So felony murder in Ohio, one example would be if I were to take a gun and I just wanted to shoot somebody in the leg to scare him or get him away from me, and that person ends up dying, I don't get off by saying, well, I didn't mean to kill him. I just wanted to shoot him in the leg. Ohio law says even if you don't intend death, if you cause injuries that result in death, you're culpable. Ladies and gentlemen, one of the last thoughts I'll leave you with is the defense keeps saying, the state can't tell you why, the state can't prove this, the state can't prove this. Well, neither can the defense. And we need to go back to what your job is actually going to be here. And with that in mind, this is what we're looking at. Forgive the crudeness of my drawing.
Hey, Michelle. Hey, everyone coming in. I saw Pixie. I saw Lillian Lower. Thank you, Augie. It's good to see you all. Thank you for being here. Yeah, early live. It's Saturday. You know, I have 3 lives tonight planned, so we might be doing a vertical too. You ready to get vertical? We're going to be covering Karen Reed next. So thanks for being here. Yeah, early. I'm on early.
That is the defense's burden. Okay, so 50% in the middle here. But it is two-pronged, as even Dr. Timmy and the judge will tell you that's the law. Not only does the defense bear the burden of proving that Sydney had schizophrenia at the time, they also have to prove by a preponderance that it was that same schizophrenia that caused her to not know the wrongfulness of her actions. So there has to be essentially a cause here that connects these two. There needs to be a cause. And you know what has never, ever made sense in this case is that even if you believe every one of the delusions or hallucinations Sydney has claimed to have over the years, not one of them, not one, would lead to violence against another. Not one. She never had a hallucination that I was feeling like I wanted to hurt somebody. I was feeling angry with somebody else. I wanted to lash out. All of her thoughts, even confirmed by Dr. Reardon, say they're all self-derogatory. That would more likely result in a patient like this of self-harm than harming another.
Woohoo! Yeah, okay.
Because it's the hallucination and delusions that are the hallmark of schizophrenia. The hallmark. Those delusions have to lead somehow to murder. Ladies and gentlemen, even if you think by a preponderance of the evidence, by 51%, that the defense somehow got over that hump, that's only half the analysis. They need to get you to that this caused wrongfulness.
You're very productive today.
That somehow it led to murder. They haven't even come close. How does shooting spider webs out of your hands like Spider-Man, or seeing water or fire come out of your hands, or any other of the hallucinations or the voices that say, I suck, I'm a loser, I'm no good, how do those lead to murder? They don't.
How do those lead to murder?
They cannot get here. It is, remember, their burden. This is the law. This is your job. You have to put your sympathy, your emotion aside, and this is what you're focusing on. Ladies and gentlemen, there have been...
I'll show the pictures again. I showed them in part 1 last live. part 6.
That.
It's good so you guys can see how the window was broken and
I
how she set that up.
That when police arrived, Sydney was fetal next to her mother. I wish that there were prior reports indicating something was going on with her mentally. I wish that Lauren Curry.
I agree, Dee.
I'm going to allow it.
I wish the evidence showed something like that, because as I said in the beginning, even in jury selection, that you have to follow the evidence. And what you didn't hear
Yay! Thank you, Dee
in
Dee.
any of the hallucinations or delusions Sydney
Appreciate
reports is a reason to kill her mother. It's not just what you hear. You got to think about what you don't hear. You didn't hear that I thought my mom was the devil and I had to kill her. You didn't hear, I can't go back to Mount Union. There's monsters there. If she makes me go back to Mount Union, I'll die. I need to kill her. It's what you didn't hear.
Oh.
None of the delusions that she reports, even if you believe that she's having delusions, can get past that wrongfulness hump. Because every one of those experts just say, well, she had a psychotic break. Well, she just had a psychotic break and she didn't know what she was doing. But nobody explains why those delusions would lead to murder. And as irrational as it might sound, the only reason you have, based on the evidence, is that she just couldn't have her mom talking to those administrators. Is it irrational? Yes. But it's not legal insanity.
Oof.
That's the evidence. And 3 experts, 30 or 300 is not going to change the evidence in this case.
He did pretty good. Okay, so that was a rebuttal. That's why they get a new appeal, because they feel like they didn't get the opportunity that to rebuttal against this. So I'm going to share, I know I've shared it in the last live, but we're going to share the crime scene photos again. And if you missed out on this, go back and watch. Sorry, I couldn't figure out, I have too many pictures on here. I have all the crime scene photos, 700 of them. I want to show you guys the window. Yeah, trigger warning. Sorry. Should have told you that. You know, I didn't realize that it is alleged that she was in the living room with her mom having a conversation. She said that's the last thing she remembers. But Brenda Powell was found in the bedroom. These are the crime scene photos, and there's a window. There's a window. She staged a scene. She said someone broke in. Sydney Powell said someone broke in, and they were able to figure out that the wounds on her hands aligned with her breaking the window and setting that up. Yeah, shout out to my girl Plunder too. She got these. That's some fun with the blood. We saw this in the Idaho 4 case where the blood is just like dripping. Those are the wounds on her hands, Sydney Powell's, where she broke the window and had, that's her in the hospital. And this is Brenda Powell. This is the slide that I wanted to get to. So we want to keep in mind Brenda Powell. She is a victim of this. My condolences and sympathies to her family dealing with Sydney, and then this, I'm sure it's a lot. So that was the rebuttal of the state. Now we're going to watch the verdict. It's only a few minutes long. I don't have the full thing on the verdict, like the full court theme, but I do have like 7 minutes worth of it. So we're going to watch it, and then we're going to watch the sentencing. It's good. It's really good. And we see her crying. Popcorn. Thank you guys for being here. I appreciate you. All right. Let me know. We good? You can see that? Okay. This is the verdict.
Thanks, Julie.
Emotions of morality aren't supposed to be involved. We're only human. It is so sad. Not buying she doesn't remember. I just don't. She can face what she's done. This is a verdict. Now we see the tears.
All right, we are back on the record in State versus Sidney Powell. Ladies and gentlemen, it is my understanding that we have a verdict in this matter. I would like to remind everyone that despite the fact that this is a very emotional case, you are still in a courtroom, and I expect appropriate courtroom demeanor from everyone who is involved in these proceedings. Thank you very much. All right, you want to let Rebecca know to bring him in?
Crocodile tears. Cry Me a River. Not Cry Me a River. Welcome to Lake China. Mary, you made it. Hello, Mary. Good to see you, love. Dee brought you in here. No detention today. I don't want to watch this like going apart, but sorry.
A reminder,
Thank you,
the
please.
23 minutes. Let's listen.
Ladies and gentlemen, the
I
jury,
agree,
it's my
okay.
understanding that we have a verdict in this matter. Is that correct? All right. Juror number 12, are you the foreperson? Would you give the verdict forms to my bailiff, please? Thank you.
Wait, so now she's really crying?
All right, I will now read the verdict forms into the record. Verdict form number 1 as to count 1 reads, we, the jury in this case being duly impaneled, sworn, and affirmed, do hereby find the defendant Sidney Powell guilty of the offense of murder as charged in count 1.
Oh.
The form goes on to say, and we do so render our verdict upon the concurrence of 12 members of said jury. Each of us said jurors concurring in said verdict signs their name hereto this 20th day of
Not trying to
September
be mean.
2023. Each juror has signed in ink next to his or her name. Verdict form number 2 reads, we, the jury in this case, being duly impaneled, sworn, and affirmed, do hereby find the defendant Sidney Powell guilty of the offense of murder as charged in count 2. And we do so render our verdict upon the concurrence
Why
of
wasn't
12
she
members of
crying
said
in the
jury.
last
Each of us said jurors concurring in said verdict signs their name hereto this 20th day of September 2023. Each juror has signed their name in ink next to their juror number. Verdict form number 3 reads, we, the jury in this case, being duly impaneled, sworn, and affirmed, do hereby find the defendant Sidney Powell guilty of the offense of felonious assault as charged in count 3. And it reads, and we do so render our verdict upon the concurrence of 12 members of said jury. Each of us said jurors concurring in said verdict signs their name hereto this 20th day of September 2023. Each juror has signed his or her name in ink next to their juror number. And finally, verdict form number 4 reads, we, the jury in this case, being duly impaneled, sworn, and affirmed, do hereby find the defendant Sidney Powell guilty of the offense of tampering with evidence as charged in count 4. Below that, it says, and we do so render our verdict upon the concurrence of 12 members of said jury. Each of us, said jurors concurring in said verdict, signs their
What's going
name
on?
hereto this 20th day of September 2023, and each juror has signed in ink next to their juror number. Counsel, do you wish to have the jury polled?
Not from the state, Your Honor. Yes.
All right. Juror number 1, is this your
Yeah, she
verdict?
didn't cry.
You need
Oh,
to speak.
quite a few
Oh,
times.
thank you, sir. Juror number 2, is this your verdict?
Yes, ma'am.
Juror number 3, is this your verdict?
It is.
Juror number 4, is this your verdict?
It is.
Juror number 5, is this your verdict?
It is.
Juror number 6, is this your verdict?
Yes.
Juror number 7, is this your verdict?
It is.
Juror number 8, is this your verdict? Juror number 9, is this your verdict?
Yes.
Juror number 10, is this your verdict?
Yes.
Juror number 11, is this your verdict?
Yes.
Juror number 12, is this your verdict?
Yes.
Counsel, do you wish to inspect the forms?
Yes, Your Honor.
Please do so.
All right. Awkward. I'm crying. What do you guys think? I'm curious. Okay. Now we're going to watch the sentencing. It's not very long, but this will be the end of the trial of what I'm presenting. So let me pull that up. Oh, hold on. Give me a second. I just closed out of it. Damn it. Oh my gosh, don't come for me. Don't come for me. Give me a break. Okay, here we go. Oh, hey, Gas Mask. Good to see you. What's up? Killa, why are you playing like that? Okay, let me pull up. Okay, I got it. Chill out. I got it. Not the Eagles coming for me. Okay, now I'm just being an ass. I'm sorry. Oh wait, I want to see her coming in. This is the sentencing. The silence, the awkward silence. What do you guys want to talk about? You want to know my secrets? Just kidding. Chill out. Good to see you, Gas Mask. I got no secrets. I'll tell you guys. Don't get Augie. Wait. There she is. Being sentenced. She doesn't look very good. I'm not trying to be mean, but she looks very like secrets don't make bread
Please
smelly.
be seated.
Tell me your secret.
All right, we are on the
I feel like it's
record
getting
in
spicy
State of
in
Ohio
here.
versus Sydney Nicole Powell. This is case number 2020-03-1008, scheduled this morning for sentencing. Present in the courtroom is the defendant with her attorney, Donald McLaughlin. Present on behalf of the State of Ohio are Assistant Prosecuting Attorneys Brian Stano and Joseph McLaughlin. Present on behalf of the victims is Attorney Jeff Laybourne. Scheduled this morning, as I indicated, for sentencing. Mr. Stano, on behalf of the state.
Thank you, Your Honor. Your Honor, before the state makes its recommendation, customarily,
Y'all,
this would be the point
she's
of
in jail.
sentencing where the court may or may not hear from the victims.
Doesn't get to make a hair appointment.
Attorney Laybourne as to whether any of the victims'
Very
family will be
unkempt.
speaking at this time.
All right, I was going to do it between the two of you,
Okay.
but I have no problem doing
Whoa.
it right now. Mr. Laybourne.
Thank you, Your Honor. May it please the court, at this time, it's the wishes of the family not to speak. As the court is aware and the state is aware, many letters have been submitted on their behalves.
Tell me your secret.
They'd like the court to review those. We know that the court has, and we appreciate that. And other than what they would like to say through those letters, no one wishes to speak today other than myself.
Oh.
The tone and tenor of those letters, I think, is consistent with what the court saw throughout the trial and what the court continues to see here today, that they love and support 𝐁𝐮𝐲 no matter what. They will continue to love and support her, and they've been a consistent and constant presence in her life and in the courtroom, and that will continue as we move forward.
Yes, he's right. The family, the dad and the grandma, they were all in support of 𝐁𝐮𝐲. I think that's great. Okay, cool. What about Brenda? Who was supporting Brenda? She was a victim to this. I'm just saying.
They love and support her, and they're going to take care of whatever that she may need. It's no surprise the court, or excuse me, the family is asking the court to impose the mandatory minimum sentence. I think that
Brenda.
goes without saying, but we will
They
say
did. They supported
anyway.
her.
Their bigger concern as we sit here today is that 𝐁𝐮𝐲 receives the mental health treatment and placement that she needs. We acknowledge, and I've explained to the family, that the Ohio Department of Rehabilitation and Corrections is in control of a lot of that. But to the extent that the court has purview or influence or can permit, we'd ask the court to permit her to participate in any mental health treatment or housing that may become available to her through the Ohio Department of Rehabilitation and Corrections. Specifically, there's a new mental health treatment center in Marysville, a 100-bed facility. Again, we understand that the court cannot place her there, but I know that they would appreciate a mention perhaps in the journal entry that any and all mental health treatment that would be available to her would be permitted and encouraged by this court. Just on a personal level, I think that a case like this exposes the tragedy of the legislature removing the discretion from judges like yourself, where you really only have a few limited options. I think that this is the type of case that would be ideal for the judge that has handled the case throughout and sat through the trial to use the discretion that we voted to give you to impose a sentence that would be more befitting the conduct and the wishes of the family, and quite frankly, the community. Lastly, Judge, I'd ask the court to consider waiving the court costs. Mr. Steve Powell posted 𝐁𝐮𝐲's bond. We are all aware, for those of us that have tried jury trials, that after a trial with transportation and subpoenas and things like that, that the court costs can become significant. And we also are aware that those court costs would be deducted from that bond amount. So we'd ask the court respectfully to consider waiving the court costs in this matter. Thank you.
Thank you, Mr. Layton. Mr. Stanhope.
Thank you, Your Honor. Your Honor, I certainly understand that no one could feel the loss of Brenda Powell more deeply than her family and her close friends. And I certainly acknowledge their support for 𝐁𝐮𝐲 Powell. Your Honor, I do want to say, because I understand the court has gotten a lot of information from Brenda's and 𝐁𝐮𝐲's close family and friends, that they do support her. Judge, I just also wanted to put on the record that our office has heard from a lot of other members of the community. And Brenda's loss is felt by the community as a whole. And a lot of those community members have, in fact, reached out to our office as well. I'm not going to repeat everything they've said, but I do want to at least note that there is a large part of the community that does feel that justice was served in this case, and the jury did get it right. And the sentence the court has imposed will reflect justice in this case. I certainly understand there are conflicting views in this case. There were during trial, and there will be for a very, very long time. That said, Your Honor, what the state is requesting at this time, certainly the murder counts are 15 to life. There is no discretion in that, as the court and counsel are well aware.
No victim statement.
Your Honor, we are asking for a, well, first, the felonious assault. The state is not conceding that will emerge. That's certainly within the court's discretion and view. We are asking for an additional 3 years on the tampering charge, Judge. We believe that Ms. Powell's behavior in staging the scene certainly warrants an additional sentence. So we are asking for 3 years on that count for a total of 18 to life. Your Honor, the state's recommendation isn't based on any ill will or vengeance or disregard for the Powell's family's wishes. At the end of the day, Your Honor, while we always do our best to take into account victims' wishes, we represent the community as a whole. And we also try to be consistent with our recommendations, Your Honor. And there are, as this court's aware, this court sees murder cases. All 10 judges in this courthouse see murder cases tragically every year. Akron police alone they consistently average 20, 30 murders a year. And the state feels the sentence the sentencing recommendation is a fair one because not every murder defendant.
I can't believe her appeal got.
But at the same time, the state needs to be consistent and fair to everybody when it makes sentencing recommendations. We believe, based on the facts of this case, the jury's verdict, the jury has spoken, and we believe a total sentence of 18 to life is appropriate under the facts of this case. Thank you.
Thank you, Mr. Stanhope. Mr. McLaughlin.
This is intense.
Your Honor, we are asking this court for the minimum sentence of 15 years to life. And I just want to briefly address some of the issues that Mr. Stano has brought to the attention of this court. First of all, there's the merger issue. I would respectfully submit to the court that the case law fully supports that the felonious assault conviction does merge with one of the two or both of the murder counts. They are allied offenses of similar import. I think the court has heard all of the evidence in this case, and I don't think there's any evidence of any separate animus that was committed between the felonious assault as well as the murder convictions. You have heard the undisputed evidence that the acts of the felonious assault were identifiable blows to the head and stab wounds, and my recollection, Judge, is that I think Dr. Schott had testified that either of those could be fatal, either the blows to the head or the stab wounds. They were obviously all committed and proximately caused the death of Brenda Powell. They were all done at the same location. They were all done within the same period of time. And again, I don't think there was any evidence at all of any separate animus such that they should not merge and would support lawfully a separate sentence. Judge, I know this court is very much aware of the purposes of sentencing in the state of Ohio, and they are to promote the effective rehabilitation of the offender using the minimum sanctions necessary without an unnecessary burden on the state. They're also to protect the public and prevent future harm. And there are factors that this court, I know, will consider and has considered, and those factors determine whether or not this offense is more serious than other offenses committed and sentenced for the same conduct. And I would submit that a number of the factors that this court must consider pursuant to the legislature are not present with respect to more seriousness. We know that it was not Brenda's physical or mental condition or age that facilitated this offense. We know that 𝐁𝐮𝐲 Powell did not have any position of public trust, occupation. This was not an offense. This was not an offense that was motivated by race or gender. And I think when the court looks at the factors under 292912 that determine whether or not this offense is less serious than the types of offense that get sentenced, there are a number of factors there that support a minimum sentence, namely that there was strong provocation by 𝐁𝐮𝐲 and that there are substantial grounds to mitigate Ms. Powell's conduct, although those grounds are not enough to constitute a defense. Obviously, this court heard from and the jury heard from 4 separate expert witnesses that the defense had brought forth. And although the jury did not feel that this rose to the level of not guilty by reason of insanity, I don't think that there's any dispute that, and the government said in its opening statement, and I believe closing arguments, that 𝐶 Powell's mental health had some impact on the consequences and the conduct in this case. So I think when considering those factors, this is less serious than some of the murders that Mr. 𝐶 is trying to lump 𝐶 Powell and her family into. When the court
Dee says on what grounds of the appeal that they didn't get to rebuttal one of the medical professionals. So, like I said, she gets a new trial or she gets to plead out or some kind of deal. Probably a mental
considers whether or not Ms. Powell is less likely
I'm
to,
assuming.
or is more likely to commit future offenses. I think nearly all of those factors weigh against the likelihood of
I don't
any
think she's really crying.
future offenses being
I
committed.
don't know.
Ms. Powell has never been adjudicated
Oh, no real
delinquent
punishment.
as a juvenile. She has never been convicted of any previous offenses. She has never demonstrated a pattern of drug or alcohol abuse related to this offense. And I think she has shown genuine remorse. And I think that was borne out not only by the experts who testified, but also by Betsy Brown and Stephen Powell and others who testified who know 𝐶 well. When you look at the factors that determine whether or not an offense is less likely, an offender is less likely to commit a new offense, nearly all of those factors I would suggest apply here. And that is, prior to committing the offense, 𝐶 Powell had not been adjudicated a delinquent child. She had no prior criminal record. She led a law-abiding life up until this event. And there were the circumstances under which this event occurred, which is untreated serious mental disease, have been remedied. We know that 𝐶 Powell has been out on bond for 3.5 years. She has done better than perhaps any client I've ever had over 30 years as a criminal defense attorney while out on bond. You heard evidence that she never missed a dose of her medication. She looked forward to counseling. She abided by each and every one of this court's conditions that would keep her in the community. We never had any concerns or issues brought to this court by pretrial services regarding 𝐶's behavior. And then lastly, under the factors that determine whether a consecutive sentence is warranted or necessary, I just do not believe respectfully that the law would support consecutive sentences that Mr. 𝐶 is asking for. And those 3 factors are, number 1, to support a sentence of consecutive sentences, whether the offender committed one or more of the multiple offenses while the offender was awaiting trial or sentencing. That obviously is not present here. Whether 2 of the multiple offenses were committed as part of an additional course of conduct. This was all one course of conduct. I believe that's undisputed. And whether or not the offender's history or criminal conduct demonstrates that consecutive sentences are necessary. And then finally, I know that this court must also consider the wishes of Marsy's Law and the wishes of the victim, and they have been repeatedly ignored by Mr. 𝐶 in this case.
Right now?
I think the court knows that. We had a hearing on that prior to trial. Both Stephen and Betsy urged this court to not proceed with trial. They made their wishes known, and those wishes were rejected. So now at sentencing, there is this opportunity for Mr. 𝐶 to give some grace and deference to the victim for the suffering that they have endured in the last nearly 3.5 years. And unfortunately, that opportunity is rejected. Just the idea that they would simply ask this court to impose the minimum sentence and not run the tampering charge consecutive. The fact that that is ignored and the wishes of the victims are trampled upon yet again, I find appalling.
Oh no.
So I would ask the court to impose the mandatory minimum 15 years to life. And I would also indicate what Mr. Laybourne said. And you have a number of letters from people in the community. It's easy for Mr. 𝐶 to reference anonymous people in the community who don't want to be heard, who don't put their name to a letter, who don't come into court and testify. I've gotten dozens of emails full of rage and vitriol and hate and anger from anonymous members of the community that want to see 𝐶 receive the death penalty. That's not what we listen to. The Constitution demands and compels that we listen to the people who are most affected by this crime, and those are the individuals back here in this courtroom. That's who Mr. Stanho should be listening to. He should have also read the letters that I submitted from the members of the community who were courageous enough to put their name on what they are asking this court to do. And what you saw in those letters from the community are letters from police officers, letters from a teacher, and you heard from a teacher in this trial, letters from a doctor, from lawyers, from people who work with Brenda Powell for almost 30 years. Those are the people in the community that I would urge this court to consider the opinion of, the people that know this family well. I would ask the court, as Mr. Laybourne had indicated, to do whatever you can in the journal entry to ask the Department of Corrections
No
to
detention
consider
today. You're good.
giving
Here you go.
Sydney a bed at the new reformatory for women mental health facility. I know that this court is very limited in what
to
you
see him.
can do, and this will be up to the Department of Corrections, but I would ask the court to consider doing that. Your Honor, for purposes of moving forward, I know you're going to advise Ms. Powell of her rights to appeal. I have done that as well. I believe that Ms. Powell is indigent, given the sentence that this court will impose. I would ask the court to appoint appellate counsel for her, and I would join in Mr. Laybourne's request to waive the court costs and consider doing that in this case, given that Mr. Stephen Powell had put up the bond in this matter. And I would just end with, I think, a letter from a doctor from the Akron Children's Hospital that really sums up what I believe are the overwhelming sentiments of not only the victims under Marcy's law, but our community. And that doctor said, and I quote, "I've almost never felt so strongly that I need to offer a voice of advocacy as I have in this tragic situation of an unfathomable verdict and the tragic current of ripple effects that will undoubtedly have upon this loving family. I have repeatedly heard from those who know Brenda well, their intimate knowledge of Brenda, her family, her husband, and Sydney, that they have endured incredible loss as a result of Sydney's actions on that horrible day. Even so, it is literally beyond words and many people's comprehension how tremendously loving they have been and remain towards Sydney in their clear knowledge of her mental illness and impairment, and the powerful clarity that Brenda herself, if she were still alive, would without a doubt want the unwavering support of Sydney's continued treatment for her mental condition.
What about Brenda?
In the least restrictive environment possible, with as much family connection and contact as is possible."
Getting a little
That's our community. Those are the people that know this family well, not some anonymous person who contacted the Summit County Prosecutor's Office and supposedly spoke to Mr. Stanho, not some amorphous thought of the community. The people who know this family, the people who know Brenda, the people who know Sydney, all asking this court to consider the constitutional wishes of the victims and impose a minimum sentence. Thank you, Your Honor.
Thank you, Mr. 𝗿𝗓𝗃. Ms. Powell, is there anything you want to say to me at this time?
Ooh.
I have advised Ms. Powell that given the nature of her appeal, she should not make a statement.
And I understand that, but I have to give her the opportunity to do so. All right. Thank you very much. First of all, to the victims, to the family and friends, I am terribly sorry for your loss here. I cannot imagine what you have been through. I have received and read all of the letters that have been sent to me. I have considered the evidence that was brought into evidence at the trial, the statements of counsel, and all of the information that is before me at this time. I do find that counts 2 and 3 merge with count 1 for purposes of sentencing in this matter. Based upon the facts and circumstances of this case and in consideration of the relevant sentencing factors, including seriousness and recidivism, and applying the minimum sanction that the court has determined will protect the public and punish the offender without imposing an unnecessary burden on state and local resources, the court imposes the following sentence. On count 1, ma'am, I sentence you to an indefinite sentence of 15 years to life in the Ohio Department of Corrections. On count 4 of the indictment, I sentence you to 3 years in the Ohio Department of Corrections. Those 2 sentences to be run concurrent with and not consecutive to each other. Ma'am, please understand that on count 4 of the indictment, you may be subject to a period of post-release control upon your release. And if you violate that post-release control, the Adult Parole Authority is authorized to return you to prison for up to 9 months for any single violation and up to 50% of your prison sentence for all violations. Please also understand that if you're placed on post-release control and you are convicted of a new
It is a big
felony,
range, Jim.
in addition to being punished for that new offense, the judge could add an additional consecutive 1-year period of time in prison, whichever is greater as a maximum. Ma'am, understand that you have a right to appeal this decision.
She
That
did.
notice of appeal must be filed within 30 days of the sentence.
And it got approved.
Entry. Your attorney has indicated to me that you are without funds to hire an attorney to represent you for appeal. Is that correct? And you wish for me to appoint counsel to represent you.
I have to pause because we know that the appeal got approved on grounds of them not being the medical profession, something with the medical professionals testifying. So she gets a new trial or gets to plead out, but also her attorney is like really close to the Powell family. So he ended up taking the case without getting paid. People question that, but
I will do
I don't
that.
know.
We will try and get that
Maybe.
done before you leave the Summit County Jail.
Such
Ma'am, I will not fine you. I will not assess
Wait.
you court costs in this.
pause, 15 to life. And then 𝐁𝐿𝐴, whose calls we're covering tonight. I hope you guys can make it. We always get wild there, but she got 25 years for DUI and killed Samantha Miller. And then Sidney Powell kills her mother 30 times and stabs her in the neck. But she's only getting 15 and now her appeal's being overturned. I don't know. What do you guys think?
Matter. Counsel, is there anything that I have forgotten?
I neglected to mention earlier,
I'll say.
we appreciate the court's deference to Ms. Powell and the opportunity to allow her to.
Something's not making sense.
Portions of the trial. I know that it is rather unprecedented, but we really appreciate the court's compassion in allowing that.
So when her lawyer talks, she doesn't cry?
Thanks are necessary. Good luck to you, Ms. Powell. Thank you. We're adjourned.
All rise.
Oh. Yeah, she's young. She still gets the opportunity to have a life. I agree, Jim. This is a sick joke of a sentence. If she gets 15 years for doing that, then 𝐁𝐿𝐴 should get 15 years too. We've been covering that here, the appeal. We're going to cover the calls tonight, more of them. Anyways, so her her conviction is being overturned. Like I said, we're going to either see a new trial with Sidney Powell in 2025, or she's going to plead. They're going to offer her a plea deal, and she'll probably end up in a mental hospital, or she'll probably end up on bail, being monitored by mental health professionals and law enforcement. I don't know. Is that justice? Is it? That's sad. Anyways, here's Brenda Powell. Let's keep her in mind. This is the victim of this crime, whether it was her daughter or not, and there was mental health issues or not. Uneven justice system. Her actual present, yeah, because then you get like good time and all that. So we'll see. We're gonna stay caught up on this. I appreciate you guys for being here. I have another live scheduled shortly. Karen Reed, who follows that? The Karen Reed case. In other words, she will be a free woman. Right. Kill a swag. Bye, Sidney Powell. Yeah. I mean, from all the true crime I cover, though, I don't hear that a mental hospital is better than jail. I hear that some mental hospitals could be pretty brutal. So we'll see. I love y'all for being here. Love you too, Jem. I will see you guys shortly. We have 2 more lives for today. Grab your drink, grab your popcorn, do whatever you have to do. R.I.P. Brenda. I send my sympathies to the family of Brenda Powell, I will see you guys shortly. I hope you guys can make it to the Karen Read. We're going to be reading text messages literally like right after this live. So I'm sure you guys will get a notification. If not, you know how YouTube works, but I will see you shortly in the next live. Thank you. And I appreciate you for being here. Bye.